My fifth mantra of LegalUX is principles over preferences. Lawyers, generally speaking, will have authority for their legal and factual premises. They'll cite to a case or they'll cite to the record when they make a legal or factual point. But almost without exception, lawyers do not have authority for their strategic decisions or for their execution on their strategic decisions. For example, in which arguments to keep in versus omit, which things to subordinate or put into footnotes, which fonts to use, how to style your margins in your document, etc. For example, do you mind the distinction between the relative pronouns that and which? Do you hyphenate your compound nouns? Do you use the word shall in your legal drafting? Do you use footnotes in your briefing or other forensic legal writing? These are a handful of examples that have correct, irrefutable answers to them that lawyers just simply don't care about. They'll just default to their preferences. To combat this problem, try expressing your ideas in different languages. I don't mean communicating them in Spanish or Italian or in Chinese or Mandarin. What I do mean is communicating them, for example, mathematically or probabilistically, or using memes or GIFs or images, depending on who you're communicating to and what it is you're communicating. A simple example I came across a couple of weeks ago is a mathematical expression of an idea. The idea is that doing a little bit of growth and change every day will go a long way. That sounds like a fine idea, kind of maybe hard to measure, but I don't think most people would disagree with that. Just do a little bit if you can every day. But it was stated mathematically as follows. 1 to the power of 365 equals 1. But 1.01 to the power of 365 equals 37.78. In this context, the difference between 1 and 37.78 is pretty large. And it's stated for you in black and white, plain terms that you can see, understand, and you cannot really argue with. There is immense power in little change every day. What about probabilistically? Well, take either of the problems listed above, that versus which, or hyphenating your compound nouns. Take that versus which, right? In American English, we use the relative pronoun that restrictively and which non-restrictively. And whether you mind that distinction depends on the following probabilities. There is a portion of the population that you write to who's going to know the difference. And there's a portion of that population who's not going to know the difference. Doesn't matter how big or how small those populations are. Those are the two camps. There's no third camp. You either know it or you don't know it. If you don't know it, it doesn't matter. You're not going to know one way or the other whether the advocate before you has used it correctly. So that's not going to change anything. The probability of somebody who does not know the difference doing something bad to you or thinking poorly of you for that reason is 0. It'll never happen. Now you got the group of people who do know the difference. They will know when you do this correctly. And a portion of them, a large portion of them, will judge you accordingly. They will think less of you. They will think you're less authoritative than you would if you use the distinction correctly. Stated differently, if you use the distinctions correctly throughout, they're going to give you more credit because they know the difference. So the probability that you're going to have something bad happen to you if you don't do it is a non-zero number. Who cares how big it is? It's a non-zero number. 0, non-zero. So probabilistically, you need to mind the distinction between that and which. And stated differently, if you continue choosing not to, you are doing something that is minus EV. It is a move or a play that has a negative expectation for you. Because in the long run, you put that before 100 readers, a non-zero portion is going to notice if you do it incorrectly, and it'll have a negative consequence for you. Other ways of communicating like this, memes or GIFs or other images, really show how the internet has changed our way of not just communicating, but our way of thinking. And so typically for internal documents, When you come up with your theory of the case, you frame your issues in 75 words or under in internal documents that get your mind focused on what you're doing. It's often helpful to have a meme of your case. It really gets to the essence of what your position is, so that every time you open up that Jones matter or that Smith matter or that other matter, you know in your mind's eye what it is you're working on and working towards. And then crucially, if you have more people on your team, upstream and downstream, they also are oriented by that. Everybody then begins rowing in the same direction. This can be helpful when communicating to your clients as well, because they're going to have their preferences and their demands and their eccentricities. But it all comes back to the meme. It all comes back to your theory. It all comes back to what fits within that 75 words that is going to make the issue turn in your favor or to the other party's favor. And this helps you communicate with your internal stakeholders as well as your external stakeholders. So when you're thinking about why this is so important, consider the following idea. In a law office, you have a senior attorney like a partner and then a junior attorney like an associate, for example. Okay, the preferences of the partner trump the preferences of the associate. That's like a non-controversial idea. That makes a lot of sense. They're the partner. Their preferences should trump the associate. But what if it's the partner, the preferences of the partner trumping what are principles? Oh, now that's a different thing. That's not good. That's very bad. The preferences of somebody should never trump principles. Principles always trump preferences. If you're in a law office where it's just the preferences of one person over whatever else, you need to really evaluate what you're doing there and what your medium and long-term goals are in an enterprise like that. Are you going to be able to grow and develop into the effective lawyer you want to if you're always going to be subject to the whims or the preferences that are not tethered to principle, that are not tethered to reality? The answer to that question is no, you're not. It's going to be very difficult for you to grow into the lawyer that you may perhaps want to be. Maybe you don't mind. Maybe you don't mind switching around. And again, most people are never going to mind with this stuff. That's the way that it should be. This is how you're going to differentiate yourself from your peers. So I'm going to close this concept with a heuristic, something that you should consider when you're doing something. Your next thing. Does your law office have a house style, or does each partner have their own style? My guess is that each partner has their own style, both in terms of like what font you use and how you format your documents, and whether you have your titles like bold, all caps, underlined, italicized, small caps, but initial letter capitalized. I mean, it's truly mind-numbing to see the preferences in the minds of these lawyers just doing this nonsense. There is a robust body of research and of writing and of thinking on what are the best practices. And there's a range. It's not always black letter, do this, not this. There's a range of acceptable, but what most lawyers do falls way outside of the range. It's capricious. It's just what they prefer. Again, do you have a house style, or does each partner have their own style? If you have a house style, well, then invariably, you know that principles trump preferences.